assert your client's right to a speedy trial, and when do you waive the client's right to a speedy trial? You do this first. As an attorney, I always put these decisions to my client, and I explain the risks and the benefits of waiving your right to a speedy trial and asserting your right to a speedy trial. Recently, we got our client's case dismissed because we asserted their right to a speedy trial. The case had been languishing for years. It had been sitting in the warrants department at the DA's office for years. Nobody had acted on it. It was only when he got into an accident and called the police that the police ran him, found out he had a warrant, and then took him to jail. Under those circumstances, we explained, look, there's no downside to asserting our right to a speedy trial and forcing the state to explain why it took so long to bring you to trial. And when we did that, the judge agreed with us that he'd been prejudiced and that his case should be dismissed. However, most of the times, our clients decide to waive the right to a speedy trial. Why do they do that? Because if the state can prove the case and you assert your right to a speedy trial, you may not be able to get more time. And so essentially what that might mean is that you'll end up on probation or in prison after you've asserted your right to a speedy trial. Now, more time may give you more options. It may change the state's feelings on cases. The victims may change their mind about how seriously they're taking the case, and you may have more options after some time has passed. So usually 99 times out of 100, 90 times out of 100, vast majority of the time, it makes sense to waive your right to a speedy trial. But sometimes you have to use it and get your case dismissed. And knowing when to do that is the difference between a skilled defense attorney and somebody who's just giving advice on the internet.